My name's Thom Clark. I work for the European Union Intellectual Property Organization, and I'm going to be doing a presentation on the examination of non-traditional trademarks. Looking forward to this and hoping to present to you some of the examples that we actually have here in the office. The presentation will be divided into three basic parts. First of all, the legal framework. Following on from that, types of marks and the requirements that we actually need to file them. And then a large number of examples of each different type of mark, which will give you an idea of what we've actually been receiving here in the EUIPO. And as Corey said, I look forward to answering your questions at the end. So let's start with the legal framework. The new legal framework came into force on the 1st of October 2017. This was basically what we called the legal reform. It was a change in the legislation. And the legislator went about the abolishment of the need for the sign to be represented graphically in two stages. First of all, the corresponding requirement was removed from the definition of what may constitute an EU trademark in Article 4 of the new European Union Trademark Regulation. And then a comprehensive set of rules concerning the representation of the sign was added to Article 3 of the new implementing regulation with a view to providing guidance on what could be accepted under the new system. So this was a basic change in the way that we look at this type of mark. If we look at the new definition of an EU trademark, it becomes apparent that the requirement of graphical representation hasn't just been deleted, but it's been replaced by an open clause requiring that the subject matter of the registration be represented in a clear and precise manner. This introduces considerable flexibility in the system, allowing it to adapt to new technological developments, but this flexibility is delimited by the need to always comply with the principle of clarity and precision. This is further explained in the first paragraph of Article 3 of the implementing regulation, which lays down the new general principles governing the representation of the sign. After confirming that the trademark may be represented in any appropriate form, which is a bit of a change, this provision introduces two limitations. First of all, it requires that the technical means through which the mark is represented use generally available technology. And secondly, it introduces quite a high threshold of clarity and precision, which is only met if the representation is also self-contained, easily accessible, intelligible, durable, and objective. So this is quite a change. First of all, we have the change to the idea that we can actually represent the mark on generally available technology, which expands it, meaning that we can always start developing new technologies on which the mark might actually be represented. And then also it does actually say what we have to do. So the idea that it has to be easy to understand, accessible, intelligible, durable, and objective. This actually makes the examination of the trademarks much easier because it shows the different criteria of which we actually have to apply. So that is the legal framework. That's what the way in which we have to work according to the legislator. Let's now go on to the different types of marks and the requirements. What we have here is a list of the different types of marks, which is laid down in Article 3. And there we have specific rules on the relationship between the type of mark, its representation, and its description, by making it clear that it is the representation that defines the subject matter of the registration, and that the type of mark and its description must be in accord with the representation and cannot extend its scope. Then, in Article 3 of the implementing regulation, it contains definitions for 10 of the most clear types of trademark, by adding the 5 expressly regulated in the old implementing regulation. And it also lays down specific representation requirements for each of them. In fact, there's actually only one of these marks which is a new type of mark, and that's multimedia marks. Position, pattern, and hologram marks are already accepted under the previous regime as figurative marks, whereas sound and motion marks are accepted if filed either as musical notation or as a sequence of still images. However, 4 of these, namely sound, motion, multimedia, and holograms, can now be filed in an easier and more accurate manner by using electronic means. So the 5 existing types of mark were word, figurative, shape, and color. And in Article 3, we also have a clear definition of these categories, and it lays down specific representation requirements for them. This basically means that we have 2 objectives. It makes it easier not only to have legal certainty and reduce, but it also means that we can reduce the deficiency rate in formalities and absolute grounds objections. So with the 5 existing types, which we see here, that's fairly clear because we already know more or less what they are. And the new types of mark which are added, position, pattern, motion, multimedia, and hologram, then we have those which are far better defined. Let's now briefly see the representation requirements for each type of mark. So here, first of all, we have figurative marks. With figurative marks, it's not possible to have a description. So this is seen as being what you see is what you get, meaning that applicants are only asked to reproduce the verbal or the device elements graphically. It's new that you can't actually have a description for us. Before you were able to, and also there's no color claim. What you see is what you get. That's all there is, no description whatsoever. For shape marks, there are new rules as well. First of all, the definition has been expanded, and it now comprises of any sign consisting of or extending to a 3-dimensional shape. To make it clearer that this type may not only cover shapes per se, but also shapes combined with word or figurative elements, or with any other element of surface decoration, which is affixed to the goods or on their packaging. Secondly, the rules allow to represent shapes by filing of computer-generated images or animated designs, as an alternative to the standard reproduction by means of drawings or photographs. So that, again, this expands what we've had before. As regards position marks, the law expressly requires the element that don't form part of the sign to be visually disclaimed, for example, by broken or dotted lines, while with regard to the pattern marks, the representation must clearly show the pattern of repetition. In both of these cases, the representation can be accompanied by a description, but again, in both cases, it is optional. In the case of colors per se and color combinations, the implementing regulation continues to require the addition of a reference to a generally recognized color code for the sake of legal certainty. With regards specifically to color combinations, the new rules reproduce to the statement of the court in the Heidelberger case, that the colors must be systematically arranged in a predetermined and uniform way, which in effect requires that the approximate ratio and the positioning of the colors be shown in the representation itself. Applicants can file a description detailing how the combination is to be applied to the goods, but this is not compulsory anymore. And this is another step in the direction of a what you see is what you get philosophy. In the case of sound marks, the first step taken by the legislator was predictably to remove the obligation to file the graphical representation. This means that there's no longer any obligation to actually have musical notation. And as from October 2017, it was possible to file an MP3 file containing the sound, and that would be enough. However, the new rules have kept the possibility to file an accurate musical notation as an independent option, so as to cater for the needs of trademark owners who need to use their European trademark as a basis for a Madrid filing, or to claim priorities in jurisdictions where graphic representability is still the only option. And the same permissive approach that allows for a choice between various means of representation has also been followed for motion marks, which may be filed either by means of a video file or by using a series of still sequential images. If it is a still sequential images, we actually allow any number of these to be applied for, so long as they permit to see the evolution of the movement and that they can fit onto one side of an A4 piece of paper. However, this solution can't work for marks which can combine image and sound, which now come under the title of Multimedia Marks. And these can only be represented by submitting an audio-visual file containing the combination of image and sound. In these cases, the law doesn't allow for the filing of a description, apparently on the assumption that in the case of purely visual signs, a description in words would create more problems than it would solve. And finally, hologram marks. These fall somewhere between figurative and motion marks, and they can be represented either by means of a video file or by graphic or photographic means, which is capable of showing the holographic effect. The holographic effect basically being a 3D effect. So what we have there is all of the different marks and the requirements that we actually need to file them. Let's go on now to some examples. All of these examples are accompanied by the European trademark number. So they give you examples of those. And in cases where they haven't been accepted, that will also be indicated. We're going to start in the same order as I presented the marks and look at them. And what I will be doing is explaining in each case why the mark was accepted or not, both from the basis of formalities and also of absolute grounds. So let's start with position marks. The first one that we have is this. As you can see here, it's most definitely a position mark. As I said before, the outline of what has not actually been claimed has been indicated with dotted lines. And that means that the part of the mark which is actually applied for is this kind of curved arrow which is on the side of the shoe. From a formalities point of view, this is perfect. There's no problem with it whatsoever because it allows us to determine exactly what is being protected. This was also accepted under absolute grounds, presumably on the idea that the arrow is curved, that it's not normal to see an arrow like this on the side of the shoe, and also the way that it actually fits in with the contours of the shoe. So this mark was accepted. The second example that we have of position mark is this. This one was a little bit more problematic. Here we can see that in fact there is no outline using dotted lines, that in fact the image of the coat has been grayed out just to give us the idea that of what is protected. And so the only protection that is here is for the gold part, which is some of the piping which exists on the sleeves and on the back, and also some diagonal piping which goes away from that. From a formalities point of view, this is quite difficult, but eventually, given the fact that the part of the mark which was to be protected is fairly clear, the mark was actually accepted as a position mark. From an absolute grounds point of view, however, this is much more difficult. Obviously, piping of different colours is not particularly distinctive. We're very much used to seeing this on the different parts of a coat or a jacket, and we wouldn't necessarily see it as a mark of trade origin. And therefore, this was refused under Article 7.1b. This means that it was refused as being non-distinctive. So those are two examples of position marks. Let's move on now to pattern marks. The first example we have of this is this little line of buildings going along the bottom of your screen. Here we can see that there is a repetition in the buildings, that there is a definite pattern in which they form, and you can see the way in which this would actually be repeated. It's also possible to see that in the actual pattern that there is, that the first building that we see on the left-hand side would be a logical continuation of the last building that we see on the right-hand side. So we can actually see the way in which the pattern works and the way in which it would be repeated. From a formalities point of view, there is no problem here because we need to actually know the way in which the mark would be repeated, and here that's clear. Given the fact that this was actually applied for foods, there's also no problem as far as absolute grounds is concerned. It's very distinctive indeed. It's not something that we would necessarily associate with foods, and it certainly doesn't show the goods themselves. So this also was accepted. A further example was for this. This was applied also for clothing. Here we can also see that there's a distinct pattern that's involved. If our eye takes us from the top left, going down and reads the pattern, we can understand exactly the way in which it would be repeated. And that means that it would be perfectly possible to apply this to a larger area than is actually shown by the pattern mark itself. We can understand the way in which it would be expanded. And so this means that from a formalities point of view, there's no problem. From an absolute grounds point of view, also this is acceptable, given the fact that you could understand there as being a G or an inverted G, which is visible there, which is also joined up by a chain. It's something which is actually visually fairly stimulating and would actually be seen as a badge of origin. So therefore, this was also accepted. We move on to the much newer types of marks. Just to recap on this, motion marks are a separate category. Description is optional. It can be applied for in MP3 or JPEG, and that the number of images is practically unlimited if it is actually applied for in a JPEG. Let's have the first example of this. Here we can see that there is a progression, an evolution in the way that the mark actually is shown, meaning that it goes, reading it from the left to the right, to actually expand the white area in the middle to the H, which is visible in the middle, which then contracts back to the original form. So we can understand what this is. This was applied for as a JPEG, so meaning as a fixed image. It was accepted for formalities because it's understandable what the motion is, and also it was accepted under absolute grounds because it's very much an understandable and a distinctive mark. This is basically an old kind of motion mark which is applied for as a JPEG. Let's move on now to the ones which are slightly newer. Our first example here is this. I'm going to play it and then we will actually, I will give you a description of it. So here we have something which is really quite different. We start with the drop of oil, which then turns itself into an advertising slogan. This is applied for in classes 1, 4, and 37. Now there's a slogan there, but the mark is so much more than that, that it's actually visually really quite stimulating. From the formalities point of view, the mark fulfilled the requirements of clarity and precision. And moreover, there were no objections raised from a substantive point of view, and the mark was therefore registered. The fact that there's a slogan there doesn't really concern us because there are many, many more elements to the mark. Obviously, also, of course, there is the trademark name which is there, which makes the whole thing very distinctive indeed. Another example. So this was applied for in class 9 for various electronic devices. Let's just have another quick look at it. So we can understand that it's some sort of a display screen which has a movement which goes around it, presumably when it's actually started up. From a formalities point of view, as a motion mark, this doesn't actually create a problem, meaning that there is actually motion or evolution which is involved in it, that we can understand how it would actually be applied to the goods, and so therefore there's no problem as far as that is concerned. From an absolute grounds point of view, there is a bit of a problem. Screens like this are relatively common nowadays. We're used to actually seeing them. We're used to seeing the fact that they may actually have colors going round them, that they may actually change in some way. And this might not actually be seen as an indicator of origin. And in fact, this was refused under Article 7.1b, again for not being distinctive. Should be noted that this was refused under Article 7.1b for distinctiveness and not under Article 7.1e, which is for the technical effect which might be obtained. There's no real technical effect here. It is really just a motion and wouldn't be seen as being distinctive. Moving on to our next example. Here, we have something a little different. This was applied for in class 9 for, again, various electronic devices. From a formalities point of view, there isn't a problem. We can see that there's a motion here. It's been applied for in an MP, in a moving file format, and we can see what the motion is. From an absolute grounds point of view, this is much more difficult, and the mark has actually been refused, again, under lack of distinctiveness. Here, it wouldn't actually be seen as being anything to do with the mark itself. It may actually be a motion of the hands, which might be used to operate the mark. It's really not particularly clear as far as this is concerned, but it's certainly not distinctive. I don't think anybody would see a couple of hands moving like that as actually being a trademark itself. Again, as I mentioned for the last example, this isn't seen as being part of the technical effect because we can't actually see what the hands might do. However, it's very clear indeed that they're not distinctive, and so the mark was refused. If we move on to our next example, here what we have is a relatively simple geometric shape, but which is, I think, as it's on a black background, it stands out quite a lot. It rotates around itself. From a formalities point of view, there's no problem here. It's actually very clear indeed that there is a motion there. There is actually a vague holographic effect to it, but given the fact that it is just a 3D shape moving, it can be accepted as a motion mark. Also, from absolute grounds point of view, this isn't really a problem. It's very distinctive indeed. It would be seen as being a badge of origin, and so this mark was actually accepted. And another example, quickly, this one has been withdrawn, but I think it's worth looking at in any case. Some of you may actually recognize this as being a device that you've actually seen. I believe that it was applied for by Amazon. It's actually the light for their Alexa machine. And it was applied for in classes 9, 35, 41, 42, and 45. It's quite an interesting one because it comes on in a certain way. It's a little bit like the screen that we saw before, which was refused. And in this case, an objection was also sent, as this isn't seen as being sufficiently distinctive to be a mark of origin. Effectively, the mark was withdrawn after an objection was sent, so that's why it's shown as being withdrawn here. But we did most definitely object to it as being non-distinctive. From a formalities point of view, again, the motion is very clear indeed. There's no real problem, and so we can accept that. Moving on to sound marks. With these, we can have two possibilities, either an MP3 file or a graphical representation, and no description is possible for these. So let's see some examples. Well, let's hear some examples. This was applied for in classes 7, 16, 37, 39, 40, and 41 and 42. It was mainly applied for blister packs, which are things going around packaging. It's a sequence of 6 notes, two sequences of 6 notes, which change slightly. Then there are keyboards behind it. I think you'll agree that it's relatively distinctive. I think if you heard this, you'd probably be able to repeat it, and you'd be able to understand that this is a mark of origin. This was accepted for absolute grounds. Also for formalities, there was no particular problem with it because it's very clearly a sound indeed. Another example for you. Here what we have is a 2-part melody. The first part is distinctive. It's sufficiently long to be understood as being a badge of origin. And in the second, then there's a slight variation to the first part of it, and this adds to the distinctiveness. I'm going to play it again so you get an idea of what exactly we are protecting and what we will be accepting. agree that that's perfectly acceptable. You can understand exactly what's the sound that there is there. Another example here. This is an interesting one. Obviously, this was applied for in class 12 for land vehicles. Now, this is quite a strange one because it's not something that you necessarily come across again. It's obviously just the sound of a motor. Here, from a formalities point of view, there's no problem whatsoever. It is a sound. However, from an absolute grounds point of view, there is. We refuse this mark because as being non-distinctive. Obviously, it really is just a motor. It could be pretty well any motor, not necessarily just the one of the applicant, because it happens to sound like a relatively small motor. I'm not going to play this again. I think everybody knew exactly what it was. I don't think it really differs from any other particular motor. And so that's the reason that this was refused. Moving on to our next example. This is very interesting indeed. Here we just have 6 notes ascending. From a formalities point of view, there's no problem. However, what are we thinking about as far as absolute grounds are concerned? Now, what we try and do is to go away from the number of... We go away from the number of notes because there are actually only 6 notes in the example. And how can we actually think about them? Are they actually going to be acceptable? Now here there are 6 notes. They go up in a particular way. And in fact, they are actually memorable. They can be seen as being a badge of origin. This was considered to be acceptable. Apologies, I'm having slight problems with reproducing these. My apologies. I just play it once more. That was seen as being acceptable. The next example is a little bit different. So if we compare that to the simplicity of the previous 6 notes, there's obviously a big difference. And in fact, with the one that we've just heard, there is actually going to be a problem. It's far too long to be memorable. You can't actually probably even remember the beginning of it now. And you wouldn't see it as a badge of origin. You wouldn't be able to reproduce it. You wouldn't be able to actually tell it apart from any other sort of relatively long sound mark like that. In this case, we refuse the mark for being non-distinctive. It's much too long for anybody to actually be able to understand what was happening or what the actual mark was. So this one was refused. And the last one is this. I'm just going to play that again. So is this long enough or is this not long enough? There aren't too many notes in it. And then there's background sound as well. So would it be possible to actually see this as a mark, as a badge of origin? At first, this was actually refused under Article 7.1b for being non-distinctive. The examiner considered that it didn't actually, or it wasn't long enough and that it wouldn't be seen as a badge of origin. This was then sent to the boards of appeal. They came up with the fact that the sound sequence has a certain resonance, it contains a certain melody and a recognizable structure. And they decided that it's short and memorable, but that it's not too short to be perceived. And even if a person heard this jingle, even if they couldn't accurately reproduce it, they can remember having it and they would actually recognize it at a later hearing. General life experience shows that sound sequences, for example, the length of the sound sequence applied for in the case, certainly enable the recognition of a wide variety of goods and services, or to be perceived in radio advertising as memorable. And in such sound sequence, the completely striking sound sequence applied for in this case can be classed as a sound mark. So therefore, the boards of appeal overturned the original decision and they accepted the trademark. Let's just hear it again. To me, I think that's a very good decision indeed. I can understand that as being a trademark. Also, the case law that we now have gives us an idea of the direction in which we can go. Moving on, let's see some multimedia marks. In this case, no description is possible. They're reproduced in MP4 files, obviously. And by definition, multimedia marks are trademarks consisting of or extending to the combination of image and sound. Our first example here. As you can see, there is the combination of image and sound. So from a formalities point of view, there is no problem. From an absolute grounds point of view, also, there are lots of different elements there. It will be recognizable. You'll be able to understand that this is a trademark, and so there isn't really any problem with it. This was accepted. Another example. This is quite interesting because it's made up of two fairly distinct parts. The first part with the small figure bowing in front of what is presumably an audience to some applause would probably actually be distinctive on its own. But then the words are added at the end and that makes it even more distinctive. This was accepted for absolute grounds. Also there, no problem. Distinctive, I think you'll agree. Our next example is this.
Bolacitro!
Now again, what we can see here is something which is very distinctive indeed, and it's interesting to see that you've got, again, the mixture of the sound and the motion and also a verbal element. No problems here from a formalities point of view, and also no problem from an absolute grounds point of view. It would be understood to be a mark. It would be seen as being acceptable. Moving on now to hologram marks. This is a completely new type of mark. Again, no description is possible. They can be represented in JPEG format or MP4, but they have to contain views which are necessary to sufficiently identify the holographic effect in its entirety. Here we have very few applications. In fact, since October 2017, there have been only 3 of them. I'm going to show you one of them, which is this. Here you can see a vague holographic effect in the way that the G in the background to the G actually change. So there is actually something which is happening there, which is vaguely holographic. As an example, it's quite difficult given the fact that we have so few applications actually showing it. I have problems actually getting something which gives a good example of this. We are, however, developing practice on this constantly. We've been involved in a convergence program with the other European offices, trying to actually establish practice, and we hope that this will be published towards the end of the year. This will give more examples of what is and isn't acceptable, and also try to better define what a hologram mark is. What we're trying to do is maybe to try and keep out the background here, Again, as we have so few examples, it's very difficult indeed to actually give you one here. This was in fact accepted, given the fact that there are distinctive elements in it, and it would be seen as being a badge of origin. So we finish with hologram marks there. And that is the last example that I have of a non-traditional trademark. I hope that you found this presentation useful, that it's given you an idea of the kind of things that we're actually facing in the European Union Intellectual Property Office, and the way in which we've been looking at them, understanding them, and developing them. Thank you very much indeed for your attention. And now I look very much indeed to any questions that you may have. Thank you very much.
Thank you very much, Thom. We have a couple of questions here for you. I will read them one by one. First question is, if description is not required for sound marks and only the MP3 format is required, how can the examiners search for similar or identical marks in order to determine the distinctiveness of the mark?
That is a very good question indeed. The answer is, the answer is that it's not actually really possible, but that's the nature of a sound itself. We do actually have one example of that where the mark itself was a sound mark just of a voice saying Barça, which is the name of a football team, Barcelona, that's how it's pronounced. And in fact, there was a verbal element which was put in there. So we are actually making it possible for the verbal element to be introduced into the field of the mark so that it can be searched. However, given the fact that it's so difficult to actually transliterate things, there is no real obligation to do this. In the case of the Barca mark, which was spelt B-A-R-C-A, this was actually put there so that it was understood how the C in Barca would be pronounced. So the answer to your question is, it's not possible to actually do it. I think that with the example that I gave of the 6 rising notes, it wouldn't be actually possible to make a description of those. And of the Boards of Appeal case, again, very difficult indeed to try and actually describe it. To give you an example of the quantities involved, in fact, we're not actually receiving that many applications. I think that since October 2017, we've actually had only 97 applications for sound marks. It is a problem searching for them. I understand that, but unfortunately, there is no easy answer to your question.
Okay, thank you, Thom. I have a couple of related questions on how examiners in the EU conduct the examination of sound marks. If there is, and a related question is if there is a database that contains all of the sound marks, and how do you determine the similarity of the mark applied for with those that have already been granted?
Okay, there are 2 different parts to that question. First of all, as far as the examination is concerned, although we don't have a group which deals specifically with new types of mark, we do have a group of examiners who do a preliminary examination of the trademarks, who are seen as being a group of experts. And so that means that it's possible for them to identify the sound marks at the examination stage, at the absolute ground stage, and actually separate them and then maybe consult them either with reference persons who are seen as being, well, they're the group of examiners in the operations department who will actually take those decisions. And then they might actually even be passed up to the further instance there, which would be the knowledge circle, which is a collection of people from different departments who would then possibly take a decision on it. That's as far as the examination of it is concerned. I think all the different elements would have to be taken into consideration, meaning the length, the distinctiveness, and an awful lot of these are discussed. So as I said, we've only had 97 applications for them, but I think that in the majority of those cases, those would actually have to be taken further. As far as the comparison of the signs in, for example, opposition cases is concerned, that is somewhat more difficult. I'm not actually aware of any case so far in which where that's actually been done. And so I don't actually know. However, with the cooperation program, which I mentioned earlier, with all of the other European national offices, we are actually going into that. There are two different parts to the program. The first part relates to the formalities for the new types of mark, how priority claims should be dealt with for new types of mark, and also the absolute grounds. And then in the second part, we're actually looking at the comparison of the different signs so that we can actually have an idea of how those would be seen. Now, that's going to be very interesting, developing that and seeing that if you've got, let's say, an MP3 file, how that would be compared to something, to a bit of musical notation, whether they correspond, whether the different elements have to be shown or not. But as I say, unfortunately, until now, we don't actually have any cases. I apologize for not being able to answer your question more fully, but with the lack of case law, it is difficult.
Well, the other related question is whether you use any equipment or gadget to measure frequency, amplitude, or decibels to distinguish the mark.
The answer to that is no, we don't. But it is quite an interesting question because it actually goes back to the different things that are laid out in the implementing regulation, which actually show that we need a certain degree of clarity and precision. Now, if you're talking about sound levels or light levels, although you could obviously measure these using relatively complicated electronic equipment, we don't do that. It's actually down to the examiner to see whether they can actually see something. So, for example, if we had a case which was a sound mark in which the sound was too low to be perceptible, it would most probably be objected to at the formalities stage, because then in that case, we would actually either be able to get a new reproduction of the mark if we're actually able to hear what it is. The problem with this would be that what we obviously can't do if we have a new video file is to extend what the original mark was. So that would be quite difficult to do. But again, it's all down to the judgment of the examiner. From the loudness point of view, it would be very much on a formalities basis, because if the examiner isn't able to hear the mark or to perceive what the mark actually is, then it probably wouldn't actually be seen as a trademark.
Thank you. So another question on sound mark. Is there a standard length for the sound to be considered distinctive?
That's a
or
very
recognizable?
Again, a very good question indeed. And again, the answer is no. It's very difficult indeed to actually get to a standard length. So, and there were many discussions in the convergence program about this as to whether there should actually be a number of notes which would take the mark from being non-distinctive to then being distinctive. And there were discussions as to whether it should be 5 or 6 or 7. But in fact, it's not possible to say that, because it depends very much on the notes themselves as to whether they would actually be seen as being a trademark, or whether in fact they wouldn't be. So if you have the sequence of 6 ascending notes, which I played you earlier, that I think is perfectly understandable as far as being a trademark. The however, the other ones, I mean, if it were 6 normal notes, then 6 notes which would just be in repeated format, then of course it wouldn't be understood in any way. It would just be understood as being the same repeated note, and we wouldn't be able to accept that. So the answer is no. It actually goes on the clarity and precision of the mark itself, and not actually on the number of notes or the actual length of the sound itself.
Thank you. I assume you use Netflix, right? Because the next question is about the sound of Netflix. Is it distinctive? Is it too short?
Okay. I find this case quite interesting. I was going to include it as an example, but eventually I didn't, mainly because the mark was, it was objected to by the office as being non-distinctive. And then it was sent to the boards of appeal. And then the mark was withdrawn during the appeal process. And so there was no actual decision on whether the mark was seen as being distinctive or not. So the way the office examined it, the mark, in case you don't know, is, I think, 2 beats followed by a kind of a keyboard wash. So there are not necessarily any notes there that are perceptible. So from the office's point of view, there was an initial objection was raised and then the mark was refused. That was what the office's point of view was at that time. Personally, and this is very much my opinion, I think that it's possibly acceptable. It's a very interesting case. It's very much a borderline case indeed, and I can understand very well why the objection was raised. However, in the light of the common practice that we've actually been establishing, it would be interesting to go back to the mark and to see how we would actually assess it nowadays in the light of this practice. And I'm not sure whether we would actually go through the same procedure or not. It's very much a borderline case. As I say, what I've said about it maybe being acceptable is very much my point of view as an expert in this, but what the office did, again, I think is perfectly defensible.
Are there grounds to refuse a sound mark or a motion mark on the basis that it was derived from a well-known composition or film, or if it's in the public domain?
I believe that there is one case that we have, which was actually musical notation for a tune called Für Elisa, which I think also had the words with it. Again, the case is not necessarily particularly germane here because it was applied for before our legal reform, and it was actually shown as being a figurative mark. And so therefore the assessment of the mark, rather than being a sound mark, would have been very different indeed. Now, if it was something which was well known, being from a film or something like that, I think it would have to be assessed, first of all, according to the length of it. I think we would have to go on that and as to whether it would actually be seen as being distinctive. Whether it would be objectionable as being readily understood, I don't know. To be very honest, it's not an area that we've actually covered. It's a very interesting question indeed. The question there is whether you would actually be able to associate that as being a trademark or not. Now, then you come down to exactly who the owner is, as to whether which is not something we should be looking at. However, it's worth thinking about the owner, that if you have the owner of a well-known piece of music or a well-known sound, of why they shouldn't actually be able to protect that sound if it is actually distinctive. There are lots of different elements that come in there that we'd actually have to look at. We've been looking at interesting cases which are similar, which go back to well-known characters who are being applied for as far as figurative marks, so just the face or the image of the character. And we're actually considering these at the moment. For sound marks, we haven't got there yet. It's probably only a matter of time. And thank you very much indeed for your question, because it makes us have to start thinking about it. I'm sorry again not to be able to actually give you a concrete answer to the question, though.
So this next question relates to the examination guide of the EUIPO. Is there a specific section in the EUIPO examination guidelines pertaining to non-traditional trademarks? And a related question is, does every country in the EU make available a database for non-traditional trademarks? So I suppose this will, a related question will be, are the non-traditional trademarks available on TMView?
Right. As far as the guidelines are concerned, yes, there are specific areas which are there. we have under the examination, in the examination guidelines, we have a specific part in the formalities which deal with the mark type and the description of the representation, that you can actually expand that if you go into the link, and you'll be able to see where that is. So that's from a formalities point of view. Also from the relative ground, so the absolute grounds point of view, the reference is made not actually specifically to new mark types, but to it'll be under the either the descriptiveness or the non-distinctiveness, and there will be examples there. Again, as I've been saying, the common practice is being developed, and we're hoping to come up with something which will be published at the end of the year. Once that's actually been published, then no doubt parts of it will actually be included in the relevant part of the of our guidelines, because this is actually something that has been developed in collaboration with the EU national offices and also with user associations. And so it's something that we will actually be signing up to and very much implementing. That's as far as the guidelines are concerned. As far as a register of the non-traditional mark types is concerned, they are certainly, all of them are actually contained on TMView. So you can actually go there and search for them. If you're going to do that, I would recommend you use the advanced search. And that means that you can actually search only by mark type. So if you want to have a look at all of the different types that are there, if you're going to be doing that, I'd recommend that you look at the mark types very closely indeed. One of the things that we're trying to do with the common practice is to make sure that we have a common understanding of the different mark types, so that they would actually be classified in as the same mark type, but that might not actually be the case across the world. There'll be different mark types shown as different things. But if, as I say, if you go into TMView, into the advanced criteria, you should actually be able to search by that, probably better to actually specify the territory in which you wish to search.
Thank you. Now we shift to multimedia marks. If the application is for a multimedia mark, do the examiners examine the multimedia mark as a single unit, or should you separate the sound from the image?
Again, a very good question indeed. And here is the nature of the mark which provides the answer. The multimedia mark has to be a combination of the sound and the image. And so therefore, if you've actually got contradictory sounds and images, it's quite possible that you'll have something which will be distinctive. So to give you an example, if you have the image of a cat, that's not necessarily something which is distinctive. On the other hand, if you have the sound of a dog barking, again, not something which is necessarily distinctive. I'm thinking especially in relation to goods which would be included in class 31, such as pet foods. We'd understand with the sound of a dog barking that it would be for dog food, or the picture of a cat that it would be for cat food. If you combine those two and you have a moving image of a cat, which then combines with the sound of a dog barking, then you've got a little bit of a problem, because they're two images which are completely contradictory. If were the examiner to actually divide them, you could come up with two very different objections that were there. Once you actually put the images together, then they become something which is probably quite distinctive. So it's actually going to be the whole that will have to be looked at, rather than the individual elements that go to make it up.
One question on the procedure of the EUIPO. So does the EUIPO's Board of Appeals include technical experts in cases where the mark in question is a 3D shape?
The simple answer to that is no, that there are no real technical experts there. So it's not as if we would actually examine these in the same way as you'd examine a patent, by putting them to somebody who's actually an expert in the field. As far as the boards of appeal are concerned, I'm not sure exactly how they operate, but certainly all of the members of the boards who will be taking decisions on are very well informed indeed, And if they're not well informed, then they do definitely go and do their homework. They will go and look into the area to find out exactly what can be objected to. And so they would do the necessary research in order to be able to come up with an answer to any appeal that were made. The same thing is true of the examiners, that in order to actually to write a proper objection to a 3D mark, for example, they would have to go into it in detail. It wouldn't just be an objection on the basis that it's non-distinctive, we can't understand what it is. We would actually have to go into the detail, make a proper link between the mark itself and the goods and services in order to be able to refuse it.
Okay, thank you. Do you have to have a certain level of expertise to examine sound marks? And what types of training, what trainings do the examiners have to undergo to be able to examine sound marks?
Again, a very good question indeed. I think we're going to have to divide sound marks here into the two different categories. First of all, the ones which are represented in musical notation do present a certain problem because, of course, not everybody is capable of actually reading music. In cases like this, we actually go to experts, expert examiners who have considerable musical training, and normally they are asked whether it is actually would be seen as being a sound mark or not. We have one expert who is a trumpet player and who plays that to a very high level indeed, and so he is often asked. And also here in the legal affairs area, we have somebody who plays the violin and who also is able to read music. So we would definitely consult those people when assessing something which has been put down in musical notation. As far as sound files are concerned, there is no particular technical expertise that's necessary. However, as I said before, there are relatively few of them. Normally these types of mark are discussed in a bigger forum, so either by reference persons or by the knowledge circle. And so certainly what we try and do as far as this is concerned is to expand the knowledge as much as possible to make sure that examiners are actually aware of what's happening so that they know the area in which the office is moving and the direction in which practice is being developed. But the answer to the sound files is no particular experience necessary, no.
The next question is related to the earlier one on Netflix, in the sense that if a mark is considered initially not distinctive, a sound mark, and it's used for length of time, is it possible for that sound mark to eventually acquire a distinctiveness? And will it eventually be registered? Can it eventually be registered? So initially non-distinctive, it acquires distinctiveness over time. So how do they prove that it has acquired distinctiveness through use?
Logically, yes, because were we to object to the mark, it would be objected to on the basis of non-distinctiveness. Now, if we object on the basis of non-distinctiveness, then it is always possible to ask for it to be judged on the basis of acquired distinctiveness, obviously, if the necessary proof were provided. I don't think that there are any examples of this. Again, with 97 applications, it's not something that necessarily comes about. I think it would also depend very much on the nature of the mark itself as to whether you would actually be able to prove this, which would be really quite difficult were the mark to have such a low level of distinctiveness. I don't know exactly how it would be possible to do that, presumably with consumer surveys and things like that to actually prove the use. I would see it as being quite difficult. When we had the other example, which was the example of the motorbike engine. Now, if you have something like that, then also there might be the temptation to object to it under the idea that it actually has significant technical connection with the goods themselves. Now, in cases like that, if you raise that kind of objection in the EUIPO, then in fact that takes out the possibility of applying for required distinctiveness. So it's an interesting question. It's not something that's yet been tried, though. Just to give an example and just to show exactly what we have been doing, I calculated yesterday the number of non-traditional marks that there are, and they actually come to a total of, I think, slightly less than 2,000. And so that corresponds to less than 0.5% of all of the trademarks that have been applied for in the EUIPO. This is excluding the two biggest types of mark, obviously word marks and figurative marks. So although my excuses probably are not terribly good about there being no case law, less than 0.5% doesn't actually give us an awful lot of experience to go on. So my apologies for giving incomplete or unknown answers to your questions.
Thank you again. Let's move on to a question on color mark. Are there any rules regarding the registration of colors, or what are the criteria applied in the examination of color marks?
Well, with the examination of color marks, the most important thing is that the color is shown, and also that it has some kind of a color code with it. So in order for the type of the color to actually be understood, most applicants, I believe, use Pantone colors. Also in the regulation, it says that there shouldn't be any contours to the color. So that means that there isn't actually anything which gives you an idea that the color would be in any sort of like shape or something like that. We do come to color marks which can be problematic. For example, when we have lots of different shades of color. So we've had one mark which I remember, which was blues moving into reds, moving into yellows, moving into oranges. And this was a bit problematic given the fact that it would be very difficult indeed to give all of the color codes which corresponded to those colors. But effectively, if a sufficient number are given, it would probably be acceptable because you'd be able to understand that the colors meld, that they actually go together. Those are the only rules that are there. Color marks are relatively difficult to protect given the fact that they're not necessarily particularly distinctive, but that will depend very much on the goods and services which they're going to be applied for. Because some colors may be more distinctive in relation to some goods and services than others would be.
A question on fees. Is there any difference in the fee charged by the EUIPO if it's a combination of sound and motion?
No, there's no difference. Basically, each mark type attracts exactly the same type of the same fee. There's no differentiation between what you have to pay for a sound mark or a multimedia mark or a motion mark. They're all the same.
What would be more important in when you examine sound marks, the notes per se or the melodic content?
I think everything together. It's very, very difficult to say because again, there's so much which goes to make up a sound mark that it's difficult to say which is actually going to be the main thing. So if we take the example that I had of the 6 notes, there quite clearly it is the way that the notes ascend, the fact that you have that the notes have different times to them, which actually makes the melody itself. And so it's the whole that actually needs to be looked at. If you broke that down and you actually took the notes and you played them in a different way, it's possible that you might come out with something which would be less distinctive. Unlikely, but it's possible. So it's very much that the whole thing, it's not the fact that it's a melody. And again, you go back a little bit to the Netflix example, which you could say is non-distinctive on the basis that there's no melody there. But then again, you could say it is distinctive because it's got 2 beats and then the keyboards which go, and so the combination of the two make it distinctive. That's one of the reasons that it's such a borderline example, that there is quite a lot actually which is audible, quite a lot which is in the mark itself.
Now, a question on infringement. If a sound, a non-traditional mark like a sound or a motion mark is infringed upon, how can the owner sue for infringement of the mark, since it's something that's really very difficult to even protect?
I'm afraid I'm going to have to duck out of this question because I'm no expert in infringement whatsoever. I don't know the answer. It's unfortunately not my field. My apologies for that, but I really don't know the answer.
Thank you. There's a question on the overlap between copyrighted music and sound mark. Can the owner of a copyrighted work file an opposition or cancellation in the event that the part of the copyrighted work is filed as a trademark?
Again, a fascinating area. It's something that we have been working on and that we are thinking about. I'm not sure of the answer. I don't know if it's actually been tried. The answer, logically, is that there shouldn't be anything preventing it. Again, I'm afraid not my area of expertise. I'm afraid I'm very much an expert in the absolute grounds and the formalities field, and so as far when it comes to infringement cases and copyright, it's not really my area. My apologies.
Thank you, Thom. Maybe for the questions that we are unable to answer today, we will try to get some other answers to your questions and post them on the website.
I'd be more than happy to actually pass them on. I know exactly who to ask, and so if you'd like to pass them on to me, I will definitely get answers for them.
Okay, thank you very much. There's we have a couple of, well, we have many more questions, but I think we have time for about 2 to 3 more questions. Okay. Is there a classification system for sound marks like Vienna or Nice? Vienna or for figurative marks? Sorry.
No, there isn't. Nothing like that has been developed. And in fact, I believe that at EUIPO, they don't actually accept sound files. The only thing that they accept is musical notation. That's one of the reasons that we actually keep the possibility of having musical notation, because it would only be used in, because it could be used in EUIPO, but there's no way of classifying it.
Mm-hmm. To maintain the registration of non-traditional trademarks, what requirements do you have, the EUIPO?
I'm sorry, could you repeat the question, please?
Because some offices in Southeast Asia require affidavits of use or declarations of use for to prove that, to maintain the registration of the mark. Is there a similar requirement in the EUIPO, and what would constitute proof of use?
We don't actually ask for this kind of thing. We don't have that requirement. So I wouldn't be able to answer that question, I'm afraid.
Going back to multimedia marks, what would be the criterion to determine the distinctiveness of multimedia marks? What criteria do you apply?
It's going to be the combination of the elements there and the way in which the elements actually work together, which is most important. Obviously, if you've got verbal elements which are visible, then they're going to have to be judged in relation to the goods and services to see whether they're actually distinctive or not. But then not on their own, as we said in the last answer, in the previous one, it's very much the elements, the combination of the elements, which have to be judged. So just because there is a verbal element which might not be distinctive doesn't mean to say that the mark as a whole isn't actually acceptable. I think the first example that we had there was with some kind of an oil. And there was a reference to oil in the slogan that was there. But given the fact that there's so much more going on in the mark, it's not really a problem. My apologies, that was actually, it wasn't a multimedia mark, it was actually a motion mark. And in fact, that makes it probably even more interesting, because if in a motion mark, you can have a verbal element which isn't actually problematic. Once you then add a sound element on top of that, then it becomes even more distinctive. So it'll most definitely be the combination of the elements, the way in which they actually play together, that will give us the overall effect, and it's that will have to be examined.
I have a question here that we received in Bahasa Indonesia, and I'm going to read the translation. In the case of three-dimensional mark in the form of mineral water bottle, in the form of a water bottle with some words, how do you will the words make it distinctive, even if the bottle per se is not distinctive?
That depends on the words very much. We have quite a lot of cases like this. Normally, what we'll definitely do is we'll have a look at the shape of the bottle. But given the fact that you get bottles nowadays which come in all different shapes and all different sizes, normally the bottle isn't enough itself. If you have a word on the bottle, then it will depend on the word as to whether the whole is actually acceptable. So, for example, if you have a strangely shaped bottle which just says sparkling on it, then the chances are that we won't actually accept it, because sparkling would actually be descriptive of the contents of the bottle. And so, I mean, not necessarily descriptive, but it certainly wouldn't be distinctive for the contents of the bottle. However, if the sparkling word were replaced by something which is then has got a degree of distinctiveness, then as far as we're concerned, then the mark would be distinctive itself. So it depends very much on the verbal element itself, but then again, that taken in conjunction with the shape.
There is a question on smell and taste mark.
Yes.
It's quite difficult. So how would you compare or how would you examine the distinctiveness of a scent or a taste mark? And let's say it's submitted it's submitted and then it's accepted in the future. So how would you store the scent mark or the taste mark?
It's a very interesting question, and in fact, it's the storage of it which makes it a problem. It gives you the impression that maybe the office should actually have a room with containers in it where you can go and get the smells. And this shows us the actual problem. You can't actually represent a smell or a taste. You can describe it, but if you describe it, it's something which is completely subjective. And so it doesn't actually give any clarity and precision as far as the representation of the mark is concerned. And in fact, you can't really represent it. There was an attempt, I think, about 10 years ago to try and see if this would be possible using gas chromatograph technology. But in fact, it's not. You can't actually get an objective representation of either a smell or of a taste. So that means that rather than having to actually examine whether that smell or taste is distinctive or not, it would actually go out at the formalities stage, because we wouldn't be able to represent it. There was a case, I believe it was quite a long time ago, probably 15 years ago, which was the smell of freshly cut grass, which was applied for tennis balls. Now, everybody knows what their idea of what freshly cut grass smells like, or I have an idea. But then again, my idea probably goes back to my childhood in England, which is one idea of what freshly cut grass smells like, whereas somebody here in Spain, where it's much drier, would probably have a different idea, and which shows the whole problem behind it. So given the fact that it's not actually possible to represent it, it would go out at the formalities stage, and we wouldn't be able to actually accept it. This is one of the reasons that, in fact, I didn't actually mention it in my presentation, because it's something which isn't actually possible to represent. And so it doesn't actually form part of one of the new types of mark. Maybe in the future, but at the moment, I'm afraid not.
Thank you. We have a couple more questions, but I will only ask one more question to you.
Okay.
I'm trying to. What was the most difficult sound mark that you have examined? Or
Well, in order to actually get an overview of them, I went through all of the new types of mark that have actually been registered in the office. And I think probably the most difficult one would actually have been the Netflix case. I think the most interesting types of mark to examine are the ones which fall right on the edge. The ones which mean that you could go either way. You could accept it because there are reasons that it's acceptable, or you could refuse it. There are reasons to refuse it. So with the Netflix case, given the fact that it's such a short mark and it's got so few elements in it, it really puts the examiner on the spot. It really makes it difficult for the examiner to see whether that should be acceptable or not. And I'll come back to what I said about that, saying that the fact that the mark was initially refused by the office is probably correct. And I think it's a great pity that it wasn't taken further so that we could actually have some sort of case law from either the boards of appeal or from a further instance to actually show us the way that in which we're going. At the moment, the case law is kind of limited, that there is some, especially in the global communication case, which is quite interesting, which is where there are only a very minimal sound mark. But I think in the end, the answer is that the Netflix case is by far and away the most difficult one.
thank you very much, Thom, for your presentation and for answering all the many questions.